Attorney Tim Williams answers your most frequently asked questions.
So we handle quite a few dog bite cases here at the firm, and the analysis that goes into whether a dog owner can be held liable for the bad acts of his dog, specifically biting or jumping on people, is fairly complicated. So I'm going to do my best to try to summarize that in a succinct manner here. We often heard growing up the phrase that there's the one free bite rule in Oregon, or everyone who owns a dog gets one free bite, meaning that unless the dog had bitten someone else before that first bite, they're not responsible for it, because how else would I know my dog would bite somebody? That was true to a certain extent, although not necessarily entirely accurate, under Oregon law prior to about 7-8 years ago. And so Oregon law 7-8 years ago, when I started practicing over 15 years ago. So when I started practicing Oregon law, the rule was essentially this. You had two levels of liability in dog bite cases. You had a negligence, so common law negligence, meaning that if it's foreseeable your dog would bite and you didn't take precautions to prevent it from biting, you're responsible. That's kind of where the one free bite rule comes in, the foreseeability analysis. Is my dog a biter? Is my dog likely to bite? Well, if your dog's never bitten anybody before, never raised its hackles, never been possessive over food, never barked aggressively at people, all it does is lick people and wag its tail, then arguably you may not be liable if your dog turns around and bites, for example, a child in the nose. So, but there's that first level of common law negligence, just standard negligence in dog bite cases. The higher level, in terms of holding someone accountable, is what's called strict liability. And under that level, or that analysis, that cause of action, the strict liability cause of action, if a dog owner has a dog and the dog has what's defined by the courts as dangerous propensities that are abnormal to its class, in other words, a dog that is likely to bite, a dog that is likely to jump aggressively at people, a dog that is likely to lunge at people and scare them, that if the dog has those dangerous propensities and the action that brings the people to our office or causes the injury is a result of those dangerous propensities, so a dog likely to bite turns around and bites somebody, then it's called strict liability. In other words, it doesn't matter what the owner of the dog did to protect or try to prevent this from occurring. If it occurred, they're liable, period. The idea there is that if you're going to maintain a public hazard or a public nuisance and voluntarily do that, you're taking responsibility if that hazard or nuisance causes injury to another. So that is the incoming, at least for me, the incoming analysis for dog bite cases in Oregon. You have your general liability. Was it foreseeable the dog's going to bite? Did you act reasonably to prevent it from biting? The answers to those questions will depend on whether you're liable or not. And you have the strict liability. Did the dog have dangerous propensities abnormal to its class, and did those dangerous propensities cause the injury? If yes, they're strictly liable. Doesn't matter what they did. They could have muzzled the dog, locked it in a cage, padlocked the cage, locked the door to the room the cage was in. The dog somehow breaks out, bites somebody down the street, they're still liable. So it's strict liability because they're maintaining a public nuisance or a public hazard. A few years ago, the legislature changed that analysis a bit. And they created sort of this third tier, this intermediary tier between, remember, there's common law, strict liability, and there's this third tier, this sort of middle layer to the cake. So for economic damages, and so they carved out this economic damages analysis. So economic damages are things like medical expenses, future medical expenses, psychological counseling expenses. For example, if a child is bitten by a dog and needs counseling, lost wages, out-of-pocket financial losses, things of that nature. Those are economic damages, as opposed to non-economic damages, which are pain, suffering. So that's sort of your mental suffering, your physical pain, damages to compensate you for those things. So on the economic damages side of the equation, what the legislature did is said, look, we're not gonna let people get by with a foreseeability analysis. We're not gonna say, oh, well, my dog never bit anybody in the past, and therefore it wasn't foreseeable that it's gonna bite somebody, and I did everything I could to prevent it from biting, therefore I'm not liable. What the legislature did is, for economic damages, remember the middle tier of that cake, they said, everybody who owns a dog is now charged with the knowledge that the dog might bite. So it's as if the dog had bitten somebody before. Okay, so there's no more one free bite, because the legislature said for economic damages, you are charged with the knowledge your dog might bite somebody, and now it's incumbent upon you. It's your responsibility to take proper precautions to prevent it from biting other people. And if you don't do that, if you're negligent in failing to prevent the dog from biting other people, you are held liable even if you had no outside indication the dog might bite. So again, that's the economic damages equation. And then we have that strict liability, the upper one, that one's still in play. So if the dog had dangerous propensities abnormal to its class, and someone was injured because of those dangerous propensities, they're strictly liable for economic and non-economic damages, period. So that's still there. Common law negligence is still there, but only for the non-economic damages. But now we have this middle tier for the economic damages side. Non-economic damages, the pain, suffering, things of that nature, that is still the two-tier analysis. You have the negligence, so you have to prove that it was foreseeable that the dog might bite, and they were negligent preventing the dog from biting. Or you get that upper level strict liability cause of action if the dog was dangerous, unusually dangerous, and you were injured as a result of that unusual propensity to be dangerous, then the owner is strictly liable. Doesn't matter what they knew, doesn't matter what they did to prevent it, they're liable, period. So I guess in essence, it is a complex soup, for lack of better words. It's very fact dependent in terms of what the owner knew, what the owner didn't know, what the owner should have known had they been paying attention, and interplaying those facts and applying those facts to the law on the economic damages side, that 3-level cake, and the non-economic damages side, that 2-level cake. So that is the law of dog bite in a nutshell in Oregon.
If you've been injured and need help, Dwyer Williams Trucos attorneys will get you the settlement you deserve. Experience gets results.